right. Hello, everybody. There's a lot of noise about AB 130 in California. If you are not in the mortgage market, you have no idea what I'm talking about. And that's why I have a partner in the Wright, Finlay, and Zach LLP law firm that handles the complex mortgage litigation for some of my clients. He's the man to talk to when it comes to California and all the complexities and legal aspects of that AB 130. T. Robert Finlay, welcome to the podcast.
Hi, Alex. How are you doing?
I'm pretty good, but I'm really worried about this new law. The background that I've heard, and correct me if I'm wrong, is that Governor of California, Governor Newsom, signed into law the yearly budget that all of a sudden included some of the changes to the second liens that will impact the whole industry. All of my clients are now worried, and I wanted to make sure that I invite you to the podcast to explain to them that either they do need to worry, how do they remediate what they have in their portfolios, or maybe they have nothing to worry about. So let's get started with what is the AB 130.
Yeah, well, first off, unfortunately, I think most of your clients, if they have subordinate liens, need to be a little bit worried. What AB 130 is, it was a budget trailer bill. It was 215 pages long, and in it included all sorts of really, really important things, such as uh, amendments to the CEQA, which is California Environmental Quality Act. It included things regarding budget, and then include one page of our little, of what affects us. And while it was only one page of 215, it had a massive impact on our industry. And what it does is it it affects subordinate liens. Is basically what it affects.
Okay, so subordinate liens can be liens that were charged off, liens that are newly originated liens like HELOCs and closed-end seconds, liens that are lingering out there, or existing seasoned liens. So does it affect every loan, or it affects a certain sub loan category?
Yeah, great question. To set the stage, it affects subordinate liens secured by residential property. It does not discriminate against the amount of units on the property. It's 1 to 4, 5 plus, a multi-unit apartment complex. Anything that is residential that is a subordinate lien is impacted by this bill. It also doesn't discriminate against the type of loans. I get not question a lot. It's not just consumer loans. It could be a commercial loan on an apartment complex. It could be a business purpose loan secured by someone else. It could be an SBA loan, where they get additional security on the business owner's personal residence if it's in a subordinate position. And the law defines subordinate as if there's another loan on title at the time you record your deed of trust.
Is it
So
only
it's
deed of
something a
trust?
third, a
Yeah,
fourth.
understood. Is it only deed of trusts, or it expands into HOA liens or student loans, credit card debt? Uh,
No, it just deeds of trust and mortgages. In California, we don't have a lot of mortgages, but because they still exist, uh, all of our laws say deed of trust or mortgage. So it does, in my reading of it at least, does not apply to HOA liens, does not apply to anything's not a deed of trust or mortgage. And one thing I just want to add, Alex, is because I am a lawyer and I can't resist, but this is all, this is not intended as legal advice. This is the new law. Courts have not interpreted it yet. We're going through it on a daily basis and refreshing our opinion on it. If any of your listeners have a legal issue, they can reach out to me, their own counsel, but don't take what I'm talking about here and run with it.
I'm glad I'm not an attorney. I don't have to insert that language. But yeah, I'm not an attorney as well. So you have to listen and then consult your own attorney or reach out to Robert. So let's draft, uh, or create the understanding for my audience. What is now required for subordinate liens to have, as far as, my understanding is servicing, right? As far as servicing of the loan, to make sure that they are enforceable, right? All we talk about the enforceability of the mortgage. If you don't comply, you're not enforceable from the perspective of what foreclosure or collection of the debt.
Yeah. So, one thing I wanted to add as far as who's covered on this, as well as it applies to borrowers as well as their successors. I think that's important for everyone to know. And again, as I mentioned, it takes a snapshot in time at the time your loan's recorded. So if you're recorded in a second position today, but then the first ends up paying off, you're still a subordinate lien at the time you originated your loan, so this law would still apply. Okay, so set the stage. What the law does is it identifies 6 things that they call unlawful practices. Uh, and as I go through these, you will see where the law was coming from. What the purpose of the law was to target and hit the what they call zombie mortgages, zombie seconds that were charged off in 2010 or 12 that have been lingering out there that no one's been really collecting on. And then, but the borrower got the money and the debt still owed, and the deed of trust was never reconveyed, and the borrower was never told that the debt was forgiven. But the servicers were not actively collecting. Well, some investors have purchased up those liens as they have done every business cycle, and they're now collecting on those and asking the board to repay the amounts that they were given, sometimes with interest, sometimes without interest. So the legislature thought that that was somehow unfair, even though again the borrower got the money, so he hasn't paid it back. And so as a result, wanted to quote with this law to affect those zombie mortgages, as they call them. But unfortunately, they didn't listen to us when we were trying to provide them with advice as to why this bill didn't make sense and what they were doing went well beyond aged or zombie second liens. It affects all second liens. So, well, but I wanted to explain that because as I go through some of these things, some of your listeners might be like, "Oh, I'm not worried about those." Some of them you shouldn't worry about, or you may not have to worry about, and some you do. So the 6 things, I'll kind of paraphrase them. Number one is failure to communicate in writing with the borrower for a consecutive 3-year period.
Okay, so let's dive into that. Email, fax, phone call, and if it's recorded
Is written
retreat.
communication. So I believe that an email or a fax or a letter or anything, any communications like that, even a text, if you had the ability, that would be fine. A phone call, I would argue it's not written communication, so I would say no. Yeah, but
Recorded phone call. If it's recorded phone call, so very frequently servicers. No,
says written communications.
got it. Okay.
Question.
So now, if I am looking at the portfolio of seasoned loans, second liens, subordinate liens, I'm checking for the dates on every email correspondence and letter.
Correct. Just to make sure there's not a 3-year period. If you went 2 years and 11 months and had one email and then skipped another 2 years and 11 months and had one email, this portion would not apply to you. And one thing I wanted to add to what when you asked about phone calls and things like that. While the statute as written says written communications, if you had no written communications, but you had a phone call and you had it documented, I would go to bat, and I may want to fight that one and show substantial compliance. How the court rules on that, I don't know, but I wouldn't give up on that. I would talk to your attorney.
Understood.
So the second item is that you failed to send a required servicing transfer notice. So servicing transfer notices are required under federal law if it's a consumer loan, and under uh, may be required under state law in certain situations. So if you fail to send that transfer servicing notice each time, when it transferred from 2014 to someone, then 2017, then 2020, if one of those is missed, arguably that would be a violation.
Okay, so let's Robert. So let me just clarify that. So in my mind, when my clients run diligence for that specific line item, they would have to verify that the name on the new servicer on the servicing transfer statement corresponds to the first monthly servicing statement that's issued in the collateral as far as communication to the borrower, right? So if I can prove that I do have that letter and I do believe that it has to be signed by a servicer, I think, right? The prior servicer?
Yeah, usually there's a hello letter and a goodbye letter.
Right.
It doesn't say you need both. So if as long as you have one of them, I think we're in good shape. But again, only if it's required. In some loans, like a business purpose loan, it's often not required. It's not required at a federal level. So it's not just that you didn't send it. It had to be you didn't send it and it was required.
Okay, understood. So now, basically, the message to my audience is you have to do a scrape of all these service and transfer notices to verify the name on the new servicer and find the corresponding monthly statement to make sure that the dates of the transfer and the start of the monthly statements are all connected and there's no gaps.
Correct.
Okay.
So the third one is similar to the second, but it's the failure to send a required transfer of ownership statement because there's two different requirements. One is if your loan's being sold, a notice must go out on certain loans. Second is servicing being sold. So sometimes servicing transfers, but there's no ownership change. Other times there's both. And in that situation, when there's both, most of the time I see that the servicer sends it out on behalf of the ownership change and the servicing change all in one document. Nothing wrong with that. So that's number three. There's rubber number two.
Yeah, so let's pause there. Would assignment that's recorded in the public records constitute the sale of the loan, change of ownership, or there has to be a letter to the borrower?
So if the transfer of ownership letter is required, notice is required, which depends on the type of loan and a bunch of a variety of factors. But if that is required, then it's a specific notice that needs to go out. The assignment's not sufficient.
Uh-huh. Okay. So now they have to search for transfer of ownership documents as a part of the collateral, which is something above and beyond the assignment of deed of trust, showing that the ownership has changed.
Correct. And keep in mind too, as you know, Alex, a lot of assignments of deeds of trust are done years later and not simultaneously, and that's part of the reason for that is they want to see um, they want the borrower to know when the loan's being sold
Understood. Okay,
in real time.
got it. So that's number three. Number four?
So number four is, and I may get the order of four and five wrong, but the next one is that you are attempting to collect a debt after the statute of limitations has expired. My view of that is that in California, our statute of limitations is so long to non-judicially foreclose that this shouldn't be much of an issue. So, for instance, in California, if your deed of trust does not have a maturity date on it, so not the note, but the deed of trust,
Yeah.
you have 60 years from the date the deed of trust was recorded to non-judicially foreclose. That's a long, long time.
Right.
If there is a maturity date in your deed of trust, you have 10 years, which is still a pretty long, long period. So, yeah, I don't see that as being a major issue, but something again to talk to your team about, your counsel about.
And then the SOL, just to clarify, statute of limitation SOL,
Yeah.
acceleration. Yeah. It counts from the modification, if any, right? So if there's an original deed of trust recorded with or without maturity date, that all doesn't matter, and you really have to review if there's any modifications recorded to modify the term of the loan or disclose any new maturity dates or sort of extensions due to COVID or what have you.
Yeah, there's a variety of factors that go into determining statute of limitations. Um, I'm right now interpreting this provision as meaning that you have it, related to whether you can non-judicially foreclose or not, so I'm not so concerned about. That said, if your loan has matured, or if your loan had been accelerated, there could be some issues there that a borrower could raise. Something to talk to your counsel about on a specific basis. It's a little hard to get into that one, on a deep dive on right now.
Okay.
Okay, then the fifth is that the servicer um, uh, conduct or threaten to conduct a foreclosure after providing a form to the borrower, and it says form, quotations, or I'm adding quotations, form to the borrower indicating that the debt had not been written off or discharged, including but not limited to a IRS 1099 form. So what they're looking at here, Alex, is they're basically saying it is if you sent the borrower a letter saying that the debt was written off, you can't, it's an unlawful practice to try to collect on it now. If you sent the borrower a letter saying it was discharged, that would be an unlawful practice. My view is that all along those things may have been problematic to a lien holder if you sent a borrower something saying that the loan had been written off. We all know that lenders don't send those letters.
They
They
don't.
send something that says it's discharged. Okay, I'm sorry, that it's charged off. Why not? That's charged off. Well, that's not one of the things that's indicated in this form. I'm anticipating we may end up with litigation over that. Someone may try to argue that, well, charged off is the same as written off. Charged off is the same as discharged. We have some good case law in our favor on that. Uh, and then the 1099 issue. We actually have case law that says issuing a 1099 debt forgiveness, for the IRS is not a release of your lien. It's not a waiver of the debt. It doesn't mean the borrower doesn't owe it. So that's been case law in different jurisdictions in different parts of the country. They interpret it differently, but we feel pretty good about that position. Now, though, if you did a 1099, that would fit squarely within this fifth item that I mentioned, which is actually in the list. It's actually the fourth. I went out of order a little bit, but on that particular item, if you did the 1099, definitely want to talk to your counsel.
What are you looking for in 1099? Just a 1099 for that specific lender?
Now, a 1099 debt forgiveness. So what some servicers did back in the day when they were discharging a loan, not most of them, but some did, is they would file at the IRS a 1099-C, which shows a debt forgiveness.
Got it.
And
So,
again, the case law doesn't necessarily support that that is in fact a forgiveness of the debt, but it now is much more problematic than it was.
so now if one of my clients don't search in the portfolio for 1099-C and verify that it's a letter that was received by the borrower, sent to the borrower by the old lender, and they file a foreclosure, they're in trouble, no?
If there was a tip, yeah, they should check for 1099Cs.
Understood. Okay.
Okay, the last number six, which is probably the most important, is that the servicer failed to send a monthly mortgage statement if one was required. So
It's
what
always required if it's open, no?
generally speaking, it's required. There are some types of loans where some may not be required.
Hmm.
But if it's required, then and you fail to send one, then you have a problem. And here, a lot of times you have these older loans that maybe have been charged off that the statements were not sent during the time period it was charged off. There's an argument that statements were not required during certain time periods. There was an argument that, yeah, well, depends on the time period 10, 12, 14, 17, 19. All of those have different, many of those have different requirements as to whether monthly statements were required or not. So this one's very complex to determine was a statement required first? And if it was required, was it sent? But it also can affect newer loans. So if monthly statements were required, then and you didn't send them, that could be a problem. So for instance, I see a potential problem, I should say, for seller carryback lenders or um, investors who buy trustees and service them themselves. I have clients that are husband wives and they're in their 80s and they do this for income, and they don't necessarily send monthly statements because they don't know they're required to and they never have, and they get paid on a monthly basis. It's not a problem. It's a 12-month loan. It's a 2-year loan. So they don't send monthly statements. That now is a problem for that mom and pop, for that or for that seller carryback who took back a second lien in order to sell their house. Those aren't sophisticated lenders they may not be sending statements. So that could be a problem. So you want to make sure every monthly statement was sent.
Understood. So for my clients, you really need to scrape the collateral file, for a continuous monthly statement as a proof of your diligence to make sure that you don't have any gaps. And if you do have a gaps, then there's a problem, no?
Correct. So the six things I identified, which I'll recap real quick, which is 3 years of no communication, failure to send the servicing transfer notice, failure to send a ownership transfer notice on both of those if they're required only, and if there's a form showing it's written off or discharged, including a 1099, or if the statute of limitations has run, and then lastly, if you didn't send all the monthly statements. Those are the six things, and the court or the statute identifies those as unlawful practices.
Understood. Now, I think, based on my understanding, the law is retroactive, right? So you don't have any time frame when the loan was put in the service, right, or in inactive status, originated. It goes
So
back, right?
yeah, generally speaking, statutes are not supposed to be retroactive. However, what they did here is they put some restrictions on your ability to foreclose if you have unlawful practices. And if you want to foreclose, you have to comply with these requirements. I'll get into the certification in a second. Um, that would apply to any loan, whether it was originated 15 years ago or yesterday. Again, any subordinate lien. So what they did with these unlawful practices, they now require you to record a certification with simultaneously with your deed of trust. And they actually use the word simultaneous, I'm sorry, simultaneously with your notice of default.
Okay.
And it has to be done simultaneously. And that certification basically says one of two things. It says that, let's see, let me get the exact language here.
Under perjury of the law, I'm sure.
It is under penalty of perjury, and it must say attest to one of two things: either that the servicer did not engage in an unlawful practice as described above, which are the six things that I mentioned. Okay. Now, keep in mind when you're signed as a servicer, servicer is defined as you, the current servicer, as well as any and all prior servicers. So you're attesting that not only you didn't commit one of these unlawful practices, that your predecessor did not as well, which that's really problematic because a lot of servicers don't want to sign something saying that their predecessor did something wrong. Now, if you had a loan that was, serviced for 2 months by the originating lender and then transferred on to you, you can verify these things pretty quickly and pretty easily. But if it was transferred 6 times over the last 12 years, that's more problematic. So number one, you can say servicer, including prior servicer, did not engage in any unlawful practices, or the servicer lists all instances when it committed an unlawful practice.
And obviously, when you are the new servicer and you are signing off for the prior, you have no idea whether this was true or not. So now you have to redo all the diligence for everything that we discussed in the 6 items to make sure you can certify.
Yes, assuming that you even have the documentation. Most more recent loans, it should be you should be able to verify those things. But on loans that, those older loans, those age seconds as second liens as they call them, it might be hard to gather all that information because some of those files are not complete. Companies went out of business. So the certification must be recorded simultaneously with the notice of default, and that's created a lot of questions. Specifically is, well, what if I recorded my notice of default before July 1st? Okay, the statute is not intended to be retroactive. It's not supposed to be retroactive. Yet here it says I'm supposed to record my certification with my NOD. I can't foreclose until I've recorded that certification. Well, what do I do if my NOD was before? Servicers have a couple choices. They can, one, safest is just rescind your NOD and record a new NOD along with your certification. Some servicers don't want to do that.
That's cool.
The other option, yeah, expensive. And it's expensive. That cost gets passed on to the borrower, which is something that the legislature overlooked. The other option is you could record your notice of, I'm sorry, record your certification with, let's say, your notice of sale.
Sure.
Statute does not allow that, but I think there's a good argument that one, the statute is not supposed to be retroactive, and therefore I was impossible for me to comply at the time I recorded your NOD, and I'm doing the best I can now by recording the certification. And two, I could argue substantial compliance, like no harm, no foul. You got the certification, so there shouldn't be any detriment. Now, um, there's risk associated with that, and how a judge is going to come down on it will depend on the mood of the judge that particular day and the judge's, opinion on these things. In addition to this certification that must be recorded simultaneously at the NOD, you also have to, there's a new notice that's required. You have to mail out the certification. Okay, well, so the notice has to include a copy of the certification. And it must also tell the borrower basically that the borrower has a right to sue you. Okay. I don't see this as it's just another notice that the borrower gets. It needs to be sent out with your NOD. So with your notice of default that you send out, you're now going to send out a certification along with it, and you're going to send out this notice that says you have the right to sue me, which frankly the borrower knows they have a right to sue you anyway. So I don't see the notice being that problematic.
Robert, so let me just expand it to the overall market view of California foreclosure. Do you know if those forms were created by the service already? Are all second lien and subordinate lien foreclosures on hold right now until this is settled down pretty much?
Um, people, they're on hold while people try to understand the law and what they want to do. So I have some clients who have made the decision to record or I'm sure they haven't yet, but they may make the decision to record the certification with the notice of sale and go to sale because they think they have a clean file and they're willing to take the chance that they're in compliance. Uh, some are putting on hold, waiting to see what's going to happen. The the other piece of this is that the way the statute's written, it says you can't foreclose until you record the certification, but it also says you can't threaten to foreclose until you record the certification. And that's causing some concern with our clients because normally speaking, well, take one step back. The certification needs to be recorded with your NOD, right? There's a lot of discussions that go on and a lot of outreach, a lot of collection activity that goes on prior to recording your notice of default. Notice of default is the start of the foreclosure. So what the law is saying is now, prior to recording your certification, which is recorded with your NOD, that you can't threaten to foreclose. So servicers need to look at their letters that may be going out that say, if you don't, if you're in default and if you don't pay by such and such a day, we may foreclose. That's a threat, arguably a threat of foreclosure. Um, uh, and so some of those letters might be wanted tweaked, and some servicing training might be tweaked to say, instead of saying we may foreclose, it may be we'll exercise all our legal available remedies, something like that. So that fix should be done. But then there's also some deeds of trust specifically require a document called a notice of intent to foreclose. Well, notice of intent to foreclose sounds a lot like a threat to foreclose. I mean, I would argue it's not a threat. It's actually it's a step required in the process to foreclose, which I'm contractually and legally entitled to do. So that's what I would argue in court. But I'm sure some borrowers' attorneys are going to be out there and they're going to argue, oh well, notice of intent to foreclose was a threat to foreclose, and therefore you violated, and you did that before recording your NOD and certification. Therefore, you're now in violation of the statute. So that's something we got to deal with. The courts are going to interpret it. I feel that if it's contractually required, we should be okay. At the end of the day, arguing that in front of the court. But again, depends on the judge, depends on the judge's mood.
Yeah, so really it gives them a
Sorry. One thing I think is really important within that, though, because I got this question out, sorry to cut you off, is some servicers have come to me and said, if I can't threaten to foreclose, what the heck can I do? Can I do a loan modification? Can I do an extension? Can I do a forbearance? Can I send out a payoff statement? Can I send out a reinstatement quote? Yes. You can still tell the borrower they're in default. You can still accelerate your loan. You can still send payoff demands. You can still send reinstatement demands. You can still modify. You can still extend, do a forbearance, help the borrower out with loss mitigation like that. You can still do all of those things. You just can't threaten to foreclose while you're doing those things. Can you still accept payment if the borrower wants to reinstate or pay off? Yes. The deed of trust is still on title. And for that borrower to sell the property or refinance the property, they're more likely than not they're going to have to pay you off, and you're still entitled to submit a payoff demand, and you're still entitled to accept those funds.
Understood. So really, the law does not impact the cases where the first lien is delinquent. It's trying to foreclose on the property, and it'll wipe off subordinate lien anyway. Or if you're in bankruptcy and you sign the plan with the um, removing the second lien from the property through the discharge of bankruptcy and approving of the plan, or discharging the second lien through the bankruptcy on its own action. So those things still valid, and they would remove the second liens. If I own the second lien and the first one is not foreclosing, and I know my lien is delinquent, and I intend to start a foreclosure first before the first lien, that's what I need to worry about. Is that accurate?
Yeah, more or less, yes. Is the stat if you want to foreclose or threaten to foreclose, you got to do this certification, and so you got to make sure your file's clean and record it with your NOD. But you raised a good point there, Alex, in that if you're a second and your foreclosure is now tied up, delayed, or prevented as a result of AB 130, which by the way has been codified into Civil Code Section 2924.13. So some of your audience may hear about 2924.13. That's the code section. AB 130 was this big, massive 215-page bill. But back to my point, if you're a second and you can't foreclose or your foreclosure is delayed, yet the first is in the middle of foreclosing, and you're staring at down at them, we want as I can't get in front of you necessarily to foreclose like most seconds try to do. So, what are their options? I mean, you could still reinstate the first lien. You have that option, but that could be risky because who knows if you're going to be ever able to foreclose. And now you've advanced more money out on the first, and now you're making the first monthly payments, and you may never ever get your money. So that's concerning. Another alternative is you can reach out to the first to see if you can buy their lien. And I'm not talking about paying them off. I'm talking about buying a lien. Some first will not sell, but some will. If you can buy that first lien and you now step into the first lien holder's position, now you're the first lien holder and you could foreclose and control the situation that way. I had some clients looking at that option. Another option is you could show up at the first foreclosure sale with money and bid strategically bid in order to protect your position. And how to do that, you want to talk to your lawyer. If your foreclosure trustee is also a law firm, you can talk to them. But if it's just if it's a non-lawyer foreclosure trustee, you want to talk to your counsel. You have to be very strategic in how you go about doing it. But those are some options that exist for that second lien holder who's looking down the barrel of a first foreclosure.
Robert, so anything I can do on the federal level to sort of override the state level law?
Nothing you could do, and even judicially foreclosing doesn't work. That's a question we got from clients. Oh, well, fine, I'm just going to start judicially foreclosing. Those 6 items I mentioned earlier, those unlawful practices, all can be raised in defense of a judicial foreclosure as well. So you can't get around it that way. And of course, the statute does give the borrower several rights. The borrower can sue to get an injunction. The borrower can sue to set aside a foreclosure sale. And then the statute gives the court significant equitable options when if there's violations, if there's unlawful practices, if there's a violation of the statute. So, for instance, the court lists some, or the statute lists some of those options, and the court can, as an equitable remedy, can bar you from foreclosing permanently. It can waive your debt. It can reduce or not, can't waive the whole debt. It can waive any interest, and so it can scale back if you're owed 150,000 and 50,000 of its interest. The court could require you to waive that interest and only foreclose or only enforce the amount of the principal. So there's a lot of equitable options that the court has to punish servicers at the end of the day.
Robert, so hold on. Just one thought on this. Why can't California force it on the first liens? Because everything that we talk about on subordinate liens, they should be done on the first liens. And now, if I'm a servicer, I now have to either the record certification for second liens or do nothing on the first liens. Why make it, common?
Don't even throw that out in the ether as an idea because if this bill ends up surviving, I'm sure at some point in time someone's going to say that exact thing. Hey, well, you're doing it on the seconds. Why not do it the first? We do not want that mess involving the first liens. So don't erase that from your memory. Last thing I'd like to say though is the industry. Well, we can't do anything at the federal level from a standpoint of going to federal court.
Yeah,
Um,
quiet title.
Trying to get around the statute. What we are doing is we are filing a lawsuit. So the California Mortgage Association, California Mortgage Banker Association, Cal Bankers Association, United Trustee Association, and the Credit Union League is the five of them will be filing a lawsuit. It's actually going to be filed by my firm along with the Buckhalter Law Firm, and then we have a appellate constitutional law specialist lined up if this goes up on appeal. And the suit, without getting too complex, it's basically going to argue that this statute is unconstitutional. And with the lawsuit, which may be filed as early as this week, we will be seeking an injunction to enjoin the state, because that's who we're suing, the state of California, to enjoin them from enforcing the statute. So we will be updating, we'll update you, and I'm sure you'll update your clients, and we'll update as many people that will hear us if when that lawsuit gets filed. If we get the injunction, I won't need to update everyone because you'll hear this huge, giant scream of joy coming from Orange County, California, and everyone in the state will hear it. So you'll know when that happens.
Robert, can my clients join as plaintiffs in your suit?
So perhaps one thing we are looking for. So we have the five associations, all with members who are directly impacted by the statute. We have been speaking to a couple different potential plaintiffs that would be added as a party to it. And what we're looking for are good examples of how wrong this law is. Like, for instance, a carryback, a seller carryback lender who they've never made a loan in their entire life. They're just trying to help. They just want to sell their house. So, so they can downsize or move into a retirement community. Someone like that doesn't know enough to send monthly statements, or the 80-year-old mom and pop who have investing in trustees. Those types of groups. We're also looking for perhaps a lender who sent sent 52 out of 53 required monthly statements, and all they did was just not send one. We're looking for lenders who might say, "Hey, I'm moving out of the state of California. I'm not going to make second liens in California anymore." So good stories to tell the court. So if any of your audience or clients have those types of stories, please have them reach out to me, and we'll vet it and see if it's someone worth putting in as a plaintiff. The other way people can help is so this litigation it's not cheap, and so those associations have contributed a ton of money, and then several impacted servicers and investors have contributed money as well. But we will need more money to take this case all the way through trial and appeal. So to the extent that any of your audience or clients want to donate, they can reach out to me, and we can help them, facilitate that. Donating doesn't mean you're a plaintiff, doesn't mean you're a party. It just means that you're putting in a donation towards the efforts behind the lawsuit. We send you a letter that tells you, acknowledges the money and also tells you that you don't have any say in the litigation necessarily. But we are taking contributions from that standpoint.
I'll put a link on the bottom of the YouTube description to make sure people have an easy way to click and donate or join the lawsuit. Two of my clients have joined you as you know, and we already ran through the 6 steps for them to make sure that they have enough information to go and sort of verify their assets. But looking at the bigger picture, just to wrap things up for us, um, you know, looking back 5 years ago, companies like JP Morgan and Chase, Citi, KeyBank, PNC, Wells Fargo, and others have a huge portfolio of charged off second or subordinate liens, which they didn't sell because of the sort of PR nightmare that they're selling something they're not sure is charged off, or they still borrower still owes some money. So they were sitting on those portfolios, as far as I know, not selling it, and now I don't even know that they're sellable. They have to chop off California loans and say, we're not planning to sell it to the secondary market, just to find out if they're collectible or not. And they have to do a true write-off with 1099-C, as you mentioned, for all of those loans. So now it's a huge loss in my mind to the assets of those big companies. Am I interpreting this wrong?
It depends on how they go with it. I don't know how many of those loans those big companies are holding on to. I know they've been slowly selling them over the years, but um, I guarantee those large companies are not going to want to try to foreclose on these. They may sell them. I'm sure there's still a market because there are, for every, you sell 1,000 California loans, there's going to be some that are compliant
Sure.
that you can foreclose upon, or some investors may just want to buy those loans up and sit on them and wait for the borrower to want to sell the property, and then they have to pay back the money they actually got that they used back in 2006 to buy themselves a boat or go on vacation, whatever it may have been. There's no question that the borrowers got this money and they never repaid it. So the debt's still owed, and there will be investors. There are investors who would still be willing to buy those loans. I'm quite sure.
Yeah. So in essence, what we're saying here is the risk level is higher in California to originate the second liens, to service second liens, to foreclose on the second liens, and the old portfolio of second lien, subordinate lien loans that are within the bigger organizations like JP Morgan, Citi, etc., probably have their price reduced as far as willingness to be, then assume that liability of not being compliant. So certainly the this affects the market dynamics. I'm not sure. Yeah, I'm not sure if other states will follow. Right, California typically starts something. So what do you think? Will other states?
Sadly, that is possible. So, but our property values go up a lot faster, and so a lot of those second liens are secured where it may not be in other states. But who knows? I wouldn't. Nothing would surprise me, Alex.
Yep. So again, I
But
think
talk about the dynamics, and it this bill, if it, I don't think second lien holders right now that originate second liens are concerned. They're probably not even paying attention because they just originate and sell their loans. If they originate and keep their loans, then they shouldn't. They have no reason to be concerned necessarily about the statute. But if they want to sell them, at some point, some investors that buy these new seconds are going to say, "Wait a second, I'm worried about AB 130. I don't want to buy seconds anymore, or I'm not going to pay the premium for those seconds." At that point, people who originate seconds are gonna may not be able to make those seconds because they can't get the funding for them. And that's gonna create a problem for everyone in California because, for all of us that have 3% mortgages or 4% mortgages, whatever it is, the way to tap in and get money right now is through a HELOC or a second lien or a third lien. But if you can't do that, you can't get you can't access those funds to pay your debts or to buy things. That's going to affect our economy big time. So this it's going to be interesting to see how this plays out. Hopefully, again, our lawsuit's successful, but if not, at some point in time, the money's going to dry up for second liens, and that's gonna be a problem for our state.
I agree. Robert, thanks so much for coming to the show. Valuable information. See in the description below the link that we'll post it there with Robert to go and contact Robert and create donations or join the lawsuit, whichever you prefer. Robert, thanks again.
Thanks, Alex. Thanks, everyone. Have a good day.
Take care.